Hi there, welcome to the latest episode of my 10-minute moan. This 10-minute moan will be a wee bit unusual because it's not me alone and I'm sure it'll last more than 10 minutes. We've got a great guest joining us today, Thomas Ross KC, who is one of the leading advocates in Scotland, and I look forward to putting some questions to him and get some explanations on the hate bill that's just about to be introduced. So we'll move on now to Thomas. So, Thomas, first of all, thank you very much for coming in. I appreciate you've just come out of court today and gave us your time. So that's fantastic. One thing that disappoints me though, just came from court and you've not got your wig on. I was thinking we would maybe see the
I don't always have it on when I'm in court, as the documentary would show.
Okay. So, Thomas, the hate bill, it's received quite a lot of discussion, both in the media and in social media. First of all, as a man with a lot more insight into legal terms, etc., what do you think of the bill and now the Act?
I think people have exaggerated the actual effect of the law. Most of it already was an offence. There's a consolidation part where various laws which already existed have been pulled together, and there's been an extension of the stirring up offences to other protected categories. But it's probably not as revolutionary as people are trying to make out. But I do think it's a bad law because it's quite clear from the debate which has happened up until now, and it isn't even in law yet, that people don't really understand it. And if it's not understood by the general public, then it's not good law.
Yeah, that's an opinion that I've shared, with a layman's opinion of it, that similar to what we've seen with the Offensive Behaviour at Football Act, people could probably have been arrested the day before that Act came into power, and it just had a different name. So can you think of many instances that people could be arrested that probably would have always been arrested previously, or is there any odd crimes that could now find you arrested that wouldn't have been arrested under current law?
It's quite difficult to think of anything that wouldn't have been an offence previously. Really, the new offence is that since about 1965, under the Race Relations Act, it was an offence to stir up racial hatred. Now, that was very nearly 60 years ago. I'm unaware of a single prosecution for stirring up racial hatred in Scotland in 60 years. I think there have maybe been half a dozen in England. And the new part of the law really is it's extended stirring up racial hatred to other protected characteristics. So it's now, for example, an offence to stir up hatred against a group on the basis of age or disability or religion or sexual orientation or transgender identity or variations in sex characteristics. So it's been extended. It was always an offence to stir up hatred on the basis of race, and now it's an offence to stir it up in relation to other groups. That said, it's pretty difficult to think of a way in which you could do that wouldn't amount to a breach of the peace or wouldn't amount to an offence under Section 38, which is basically threatening behaviour. So I think probably all the conduct which could amount to a new offence would already have amounted to an offence in terms of the criminal law.
Mm-hmm. And is it a fair comparison, in my mind, to what happened with the Offensive Behaviour at Football Act, where it didn't actually create any more convictions, it didn't create any less bother at football matches, it was just a law that was there and seemed a bit of a waste of time?
I think this is worse, Craig, because I agree with you that there won't be many convictions under this Act. Nobody thinks that there will be, because the legislation is so difficult to understand that if any prosecutor has the option of charging breach of the peace or an offence under the new Act, they'll go for breach of the peace because it's much easier to prove, it's much easier to understand. The difference is that, and it is a good comparison, the offensive behaviour at football is a good comparison, but most people don't go to football, and those of us who do go to the football, you know, we might be there once a week or once a fortnight or something, whereas this affects everything that we do. You know, conceivably, every time you put something on Twitter or Facebook or you send a message to a group, it could amount to an offence, which, so it's obviously much more wide-ranging, but it's a very good comparison because when that Act came in, every one of us who showed an interest said, look, this is rubbish, there's no need for it, there's not going to be many convictions, it's going to cause confusion, the sheriffs won't like it, All the same things that people are saying about this legislation.
Yeah, and from memory, when the Offensive Behaviour at Football Act came in, there seemed to be a bit of political pressure to get charges which were aggravated by.
Mm-hmm.
Is this possible with this new bill, whereby we've created this bill, it's now law, then, you know, if someone was going to get charged with something like an assault, should they then push for aggravated by hate and potentially get a non-guilty in a case that was probably clear-cut assault?
Not when it's an aggravation, because the part of the Act which deals with aggravations, you would need to commit something which is already an offence before you could be charged with an aggravated offence. So you said assault, that's a good example. If it's an assault with a stranger, then it would be charged as an assault. If it's an assault where you've said something sectarian or racial while you're assaulting the person, then that would become an aggravation. So, and the prosecution don't lose anything by bringing an aggravation. You know, the judge might say, well, I think this is an assault, but I don't think it was aggravated, in which case he just removes the aggravation. So it wouldn't be all or nothing for the prosecution. They wouldn't lose the case because they brought an aggravation. The new offence is different. You know, if a breach of the peace was an option and they choose not to charge breach of the peace, they charge the new stirring up hatred on the basis of sexual orientation, for example. Well, if the sheriff thinks that hasn't been proved, that's an end of the case. The person isn't convicted. So that's what makes me think the prosecution would always go for the offence which is easier to prove. Yeah. That's my experience.
Well, that was something I commented on in a podcast I was invited on to about a fortnight ago. And I said, it's all good and well getting an act through Parliament or a bill through Parliament to become an act and eventually a law. But that doesn't mean folk go to jail. No. There's a few steps of the process. The police have got to arrest and then push the charges. The prosecution services have got to accept those charges and push for a case. You've then got to go to court where either a judge or some of your peers will decide whether you're guilty or not. So bringing in a law doesn't really, it's not the end of the story. There's a lot of steps still to go through. And you've already suggested that the prosecution services might not see it as an easy case. Yeah. So they may go for existing laws anyway. Is that something that you've considered?
I think that's exactly where it will go. Actually, the most dangerous part of this whole story has got nothing to do with the legislation at all. It's the fact that the police are now recording incidents which are not crimes, and that is nothing to do with the hate crime legislation. It was a recommendation that came out of the Stephen Lawrence inquiry, and the police have been doing it for years. And this week it came to public attention because Murdo Fraser, MSP, found that had a hate crime logged completely without any notice to him, and it came out as a result of a different process. So that's the worrying thing, that, you know, the police, I mean, I've been doing this job for 40 years now. I don't understand it. You know, I'm reading legislation, Kate's reports every day, and I read the part which deals with religious offences, and I don't understand it, you know. And if I don't understand it, what chance is a young cop who's just at a training school, 18 months, and they receive a complaint and they look at this legislation and think, well, I don't really understand this, but it's probably easier to charge it and let the prosecutor decide, you know, or it's easier to record it as a non-crime hate incident, and then the person, you know, could find that that's used against him or her when a job's applied for or wants to be a football coach or something.
Yeah, it's interesting that you mentioned that last line, because I run a kids football club, and I hadn't considered this until recently when the Murdo Fraser thing was made public. So as it stands just now, Murdo Fraser had a complaint against him for hate of some description. And what's happened then is that attached to him? Because Hamza Yusuf was interviewed by STV the other night, and he seemed to suggest it's a great thing for all these things to be recorded because we can then monitor spikes in behaviour. But my opinion was, you're not monitoring spikes in behaviour, you're monitoring spikes in complaints, which could be two totally separate things. So when Murdo Fraser was, obviously, I would imagine he was questioned at the time and asked for his input and what actually happened.
He wasn't.
Seriously?
He wasn't. That's the dangerous thing. What happened was an academic who is very much in favour of women's rights made a comment which was perceived as anti-transgender, and Murdo Fraser either liked it or shared it on Twitter. And then somebody complained about him because she took the view, the complainer took the view that by liking it or sharing it, he was essentially endorsing this opinion, and it was recorded as and at the same time, the person, and I can't remember if it was a male or a female, but the person made a complaint, I think, to the Parliament or to the Conservative Party. So a complaint made to the police and a complaint made to somebody else. And it was through the investigation into the complaint made to the other group that he found out it had also been reported to the police. He didn't know. He'd never been spoken to.
So basically what's happened there, a complaint's been made to the police. They've looked at it and thought, well, we ain't taking that any further. We can't see any criminality. So that was recorded. Now, was that recorded as a statistic, or was that recorded on a record about him? Was he named in the record then?
Well, he was named in the record. That's how he found out about it. And then I don't know the result of it, but the academic who made the original contribution on Twitter then had to write to Police Scotland saying, have you got my name on record as well? Because it was me. I think there was a journalist also who had reported it. So there were 2 or 3 people who had been caught up in it. None of them were guilty of anything, but had made some sort of comment in relation to it, and then became concerned, well, if they've got a file on Murdo Fraser just for saying that he liked it, have they got a file on me for making the comment? I mean, that's the really worrying thing about it, because the legislation can be debated and you can argue it in court and you can possibly succeed in court, and probably most people will never get anywhere near court. But who knows what incidents have been recorded by Police Scotland without any of us knowing about it?
Because the way Humza was describing it, it was as if it was just for statistical purposes, i.e., we've had 100 complaints in Glasgow on ageism, right, for example. But in actual fact, it's individuals. So if you complain about something I put on Twitter, the police have said they'll record it and they'll investigate it. Now, they could investigate it and think, well, we're happy that Craig didn't commit any criminality, so they might not, like they've done with Murdo Fraser, talk to me. I would be totally unaware, but the potential is that would still sit on a record somewhere about me. Is that where we are?
That's what I understand it to be. I mean, what makes it worse, Craig, is that this came out of the Stephen Lawrence inquiry. They've been doing this in England for many years, and eventually a person, and again, it was to do with transgender rights, a man made some comments on Twitter and was reported in relation to it, and subsequently found out that essentially the same thing had happened to him as happened to Murdo Fraser. And he brought court proceedings against the police, and the court, first of all, said that there was a legitimate basis for recording hate crime, but they thought that the guidance which the police had been given required to be revised. They thought essentially that it went too far. And I mean, the Scottish police must know this. They must know that this had been looked at in England and found to be unsatisfactory. And as far as I know, they haven't reformed their procedures at all. And that case was reported almost 2 years ago.
That is scary. And when you factor in, I think we both understand what will happen in the 1st of April is there'll be loads of people out there looking to be offended and find hate in whatever anybody says. And the police will be inundated with complaints at the start of this process. The police have now already guaranteed that they will investigate every single one of those crimes, or sorry, allegations. Surely that's unworkable.
Well, it must be unworkable, because they've also said that they're not investigating house breakings in Aberdeen, and they're not investigating other crimes somewhere else. And I assume the logic is that they've got so much crime to investigate, they don't have time to investigate it all. So it seems odd that they would have time to investigate everybody who phones them at 2 a.m. complaining about something they've read on Facebook. But that's what they said they're going to do.
Yeah, and it just seems an insane suggestion to make, because I mean, unless when you look at something that's quite obviously, I mean, investigation could be looking at it and thinking, no, there's no criminality there, put that back in the bin. But again, you touch on something that I done a video about last week, where the experiment up the northeast was to basically leave the production of evidence down to the person who's complaining about a crime. And if you cannot provide enough evidence, then the police would just file it in a place until possibly evidence turned up. So and then they're going to broaden that out to the rest of Police Scotland. So if you have your house broken, sorry, say your garden broken into at night, go into your shed, steal your bike, if you don't have CCTV, you phone the police in the morning, you can't tell them who it was, when it was, or you've got no way of proving anything, then that'll just get put in file until maybe sometime in the future evidence does come. But at the same time, you as a person that's lying in your bed that night might write response to something that you don't like on Twitter.
Yeah.
And the police are duty bound to investigate. It just seems bizarre to me. And something else that you can maybe give me some insight into the video I done yesterday. The Daily Express wrote an article about these PRWs, which I thought was Paisley Road West, but turns out it's a police reported warning. And they provided a lot of information in the article, but they were grabbing onto something that I saw the bigger story being fraud is now listed as a PRW. And then fraud in brackets, stealing fuel and dodging a taxi. All these crimes are listed. But the very first one listed with fraud just says fraud. Now, how do you make fraud a PRW? Something that you wouldn't go to court, wouldn't have any criminality attached to it, but just gives you a police recorded warning. How does that work?
I know what your bigger concern is in relation to fraud, but I mean, fraud could be going for a pizza in the knowledge you don't have any money and doing a runner at the end of it. That could be fraud. And I suppose something at that end of the scale, it wouldn't be surprising if you get a police warning for stealing a £10 pizza be fraud. Yeah. But you're right, they haven't put any ceiling on it. I mean, it does seem a bit unlikely that something that was on a much, much larger scale would be seen as appropriate for a warning, which really means it isn't even reported to the prosecution. It's, it ends with police action. And it's the kind of thing you get for, a tenner's worth of cannabis or grass or something.
Yeah, I think if this was brought to my attention 5 or 10 years ago, I wouldn't have gave it a second thought. I would have thought, well, obviously, that doesn't mean people in excess of £500,000 of fraud who are getting investigated currently by the police. I wouldn't even cross my mind, because in a normal, logical, common sense environment with society and running on a normal basis, I wouldn't have that in my head. But unfortunately, when you've got this law coming out, I'm going, is it stupid for me to actually be concerned about fraud? And when you see the list of crimes, there was fraud like skipping taxis. There was maybe 6 or 7 frauds listed where cover the things that you're saying, leaving a shop without paying, etc., or using a hooky Visa card when you're paying for fuel and all that stuff. They were listed and quite easy to understand what they are. But the fact that it was just fraud, and I'm thinking, 5 years ago I would never have questioned this, but the society is different now.
Listen, you're absolutely right. And there are a lot of people concerned about the fact that the Lord Advocate is a member of the Scottish Cabinet. It all comes back to that. And the reason I'm not as concerned as you about it is that I know the Lord Advocate and I've got a lot of time for her and I respect her. And, so I don't have a concern that she would do anything that fell below proper professional standards. But on the other hand, it's not fair to her. It's not fair to her or anybody who does the job that they're part of the cabinet, because at some point, the Crown Office will have to mark proceedings in relation to the various investigations which are going on. And it's really, really difficult for non-legal people to understand how somebody who's a member of the Scottish Government, as the Lord Advocate is, it can be completely impartial when considering the possibility of criminal proceedings against, the former First Minister or something like that. She shouldn't be in that position. In England, they don't do it that way. In most countries, as far as I know, no other country does it this way. So it really is something that has to be dealt with. But I always say it's not the Lord Advocate's fault, it's the legislation.
No, I think I suggested as much with a video I done about the subject about a month ago. And I said the position is not the fault of Dorothy Bain. And I don't know the women. You've obviously got a lot more professional dealings with her, and it's quite heartening to hear that you hold her in a sort of high regard. That, but the actual position is just ridiculous. That and I think again, 10 years ago nobody would have gave it a second thought. But now we're in a position whereby not only is the party in power being actively investigated through branch forum, but we've got the brother-in-law of the First Minister who got charged. He did get charged, yes, he went to court, he pled not guilty, with a crime related to drugs. He was then rearrested and charged with an act of assault, which the man's unfortunately now dead.
Yeah.
So we now have the Scottish First Minister's brother-in-law definitely up on drug charges and potentially involved in a murder case.
Yeah.
And this woman's got to sit in the same cabinet. That's no her fault. That's the process's fault. And
yeah, I mean, and when I read that story, I thought she'll never be anywhere near that. I mean, crime at that level is not going to be considered by somebody as high up the chain as the Lord Advocate. It's going to be considered locally. But in a way, it doesn't matter, you know. And ironically, the SNP made promises about this and really did nothing about it. But Joanna Cherry, who's a member of the Westminster Parliament, an SNP politician, has introduced a sort of private members bill. I hope I'm getting it right. But she has introduced legislation. She's of the view that there would have to be legislation in Westminster to separate the powers of the Lord Advocate. I'm not sure that's right, only because I haven't really had time to study it. But she is SNP and she recognises the problem, and all lawyers recognise the problem. I mean, in every country in the world, the idea that the prosecutor would really be part of the government, you know, there has to be a separation, because it's not whether there is actual bias, it's a perception of bias. And, you know, and what's she going to do? You know, if she considers the papers and considers there's no basis for prosecuting Nicola Sturgeon or her husband or the other guy who was charged, and that might be the position. There might be no legal basis for prosecuting. They might take the view there's no reasonable chance of getting a prosecution. There might be other legal problems. But people are going to say, well, what do you expect? You know, so it really puts the Lord Advocate, whoever it is, in a really, really impossible position.
yeah, it's interesting to hear your views on that. Because I think that the default of the public is, can he trust Dorothy Bain? That's maybe not true. It's just, can he trust that process? And that's where I am with the whole thing. Another thing, there's a lot of people pushing this really, really hard. And I'm interested to hear your opinion on it. There's a suggestion that the whole process is in some way unlawful and illegal. And the whole process has been unlawful and illegal since 1999 when it happened. Now, my fear is, if they're right, what happens with the 24 years worth of convictions we've had since having this unlawful and illegal prosecution service?
Yeah, I mean, I don't think that it doesn't comply with the legislation, because they say that when she basically, they say she's got two jobs. One part of her job has been part of the cabinet. The other part of the job is being head of the prosecution system. And they're basically two jobs done by one person, but they're separate. And in other words, there's no crossover. That's how they would get around it if there was any challenge to it. Of course, the other problem is it doesn't really matter what the prosecutor does, because it's all subject to the court overseeing it. So, you know, the prosecutor can't get you convicted. They can bring a case against you and present it to the court. But ultimately, if you're convicted either by a jury or at the sheriff court by the sheriff or a justice of the peace. So I think I don't see any danger of any convictions being quashed on the basis of this constitutional problem, but it still needs to be straightened out.
Yeah, because I thought if it was illegal, then is the whole process illegal? But it's not, because judge, juries, and all the courts, they were there before 1999, and you know that's where we measure whether somebody's a criminal or not a criminal. I was asked, I put a wee note on X. I struggle to call it X. It's Twitter to me,
Yeah,
innit?
me too.
But when I was coming up here to talk to you, and as anybody any questions, and there was a couple of questions. One that you've covered already without getting into it, but the other one was, and I thought it's dead interesting. Are judges going to be liable to this law? I think I know the answer, because a judge is not. He doesn't get me out of jail card just because of his job. But I think what the guy was asking was, if you were to convict somebody in a protected group,
Right.
could that person then make a complaint about you and suggest that you only found me guilty because I'm old, I'm Islamic, I'm Jewish, I'm Christian, I'm South Korean?
But they could do that 2 years ago or 10 years ago, you know. So there is a process for judicial complaints. I mean, as I said at the beginning, the only new law here is stirring up hatred against these particular groups. Everything else was already law. So I suppose it's quite difficult for me. I mean, judges don't always get it right, but it's pretty difficult for me to imagine, to be perfectly honest, a judge getting it so badly wrong that it could be argued that he or she was stirring up hatred against a particular group. You need to go some, I think.
Yeah, and a conviction's a totally different thing from a complaint, but it wouldn't bar a judge being a victim of a complaint.
And I mean, listen, we're in a society now where people complain about everything, so I've got absolutely no doubt that there are people complaining about sheriffs and judges because they lose, in litigation. Somebody's got to lose, whether it's two people suing each other over money or whether it's somebody, a person making an allegation against somebody about a sexual offence or something. Everybody can't win, there's going to be one side that wins and one side that loses. And quite often the losing side will complain about the judge or complain about the lawyer. Quite often sex offenders in particular will, after convicted, will go to the Criminal Cases Review Commission and say, well, I only get convicted because my lawyer was rubbish, Now, the lawyer wasn't rubbish, but, it's easier than accepting that they committed the offence. So I'm sure there's scope for people complaining that the judge didn't take proper account of the protected characteristic. I'm certain it's already happened in England. But listen, there's got to be a complaints mechanism, and some people will abuse it, but equally, occasionally, people will have legitimate grounds, so it's got to be there.
Again, I've got my own opinion on it as just a normal member of the public with a limited knowledge of law. But as someone with a far more experience and more knowledgeable understanding the law, why did he even do it?
The law?
Yeah, why did somebody sit 3 years ago when this was drawn into a bill and say, we need this?
I think that, as I said, 1965, we had an offence of stirring up racial hatred. And then 1986, there was a Public Order Act. And again, it was really just the same law. It was race. And as years have gone on, there's been concerns that, well, why should we restrict it to race? Why should it not include religion? Why should it not include homophobia? And in Scotland in particular, the law relating to aggravated offences against protected categories ended up in about 4 different places. So there was about 4 different acts of Parliament and acts of the Scottish Parliament which described hate offences. And we commissioned a report by a retired judge, Lord Brackadale, and he was to look into the existing law and to see whether there was any need to extend it. What we used to do is changes in law used to be considered by the Scottish Law Commission, which consists of about 10 people. So I suppose this was the kind of budget way of doing it. They get one person to look at it, and he made the recommendation, well, it's not very satisfactory that you need to look in 4 different places to see what the law is. So we should start by putting all the law in the one place. And that's half this act. The other half is, well, we'll already protect racial, stirring up against racial hatred, stirring up against religious, stirring up against disability. Should we extend it? And in addition, the way in which the protected characteristic in relation to transsexuals, the wording, the way in which the groups wanted to be described had changed as well. So it was started as a kind of tidying up exercise. And I suppose the reason they did it was to extend the protection to groups which were not protected up until then.
So it was maybe just needing tidied up. Certainly needed tidied up if there was 4 acts covering basically the one thing. So I sort of get that. But has it went too far?
Well, I think when you get to the stage when lawyers are uncertain as to what the law is. So I think probably the best example is if you said to me, Craig, if I come over there and I punch you in the face, would that be an assault? I say, aye. If you say to me, if I come over to give you a cup of tea and a trip and I head you in the face, is that an assault? No, it's not an assault because you never meant it. I can give you an answer like that without even having to think about it. That's good law, and everybody then knows, well, if I go about punching people in the face, I'm going to go to court for that. Everybody understands it. I can't understand this, so if you were to phone me up and say, listen, somebody just asked me, if this person says this on Twitter, would that be an offence? I probably wouldn't know. So if I don't know, with 40 years in the job, what chance have people got of knowing what's acceptable and what's not acceptable? And the reason it's probably gone too far is what I said earlier. It's the recording of non-hate incidents. And what I'm thinking of there is, if you phone up the police and say, look, every time I go to my kitchen window, the guy across the road is looking at his kitchen window, and I think he's looking at me. The cops are going to say, look, don't phone us back. You're wasting this time. That is not an offence. And if you keep phoning us, we're going to end up charging you with wasting police time. If somebody phones and says, Craig Houston, and gives some homophobic remark, or, remark about the trans community or something, they can't do that. They can't just walk away from it any longer and say, stop wasting our time, because that doesn't amount to an offence. They then have to consider, well, if it's not an offence, is it a non-crime hate incident? So there's that. It's the opposite of a safety net. It's not just stop wasting our time, that's not an offence and that's it. You might find yourself in a register somewhere for doing something that isn't even criminal.
There was two things that I read, right, that caught my imagination right off. One of them, it was a technicality. Collaboration is not a bad thing. I would imagine that's not a bad thing when you're on the defence side of the law, right? You quite like that being there.
Oh, it's a better thing if you're getting charged with something you didn't do, because it's going to be more difficult to prove it,
Correct. And none of your clients done what they were.
Well, I certainly didn't. They might have done. But I would think it's probably more a protection to the guy who's going to jail for 25 years rather than me, who's going home at night.
Yes, aye. So collaboration is not a bad thing.
Right.
But there's a part in this new law where collaboration is taken away. And it's a perception of the person who feels they've been criminalised.
I know. Well, that's to do with the aggravation. And I suppose the logic of it is, unless there's two sources of evidence, you won't be convicted of the offence. So in other words, if it's an assault aggravated by homophobic aggravation, they need to have two witnesses to prove the assault.
Oh, yeah.
They don't need two witnesses to prove the aggravation. And I suppose the argument is, well, if you didn't commit the assault, or there's only one witness to you committing the assault, case is over. The aggravation. And it actually exists in quite a lot of other areas that they don't need to prove the aggravation by two witnesses.
Okay, let's say I've committed an assault. You're defending me, but that would have been a few years ago, because that's well above you now, right? Well below you now, an assault case.
Depends how bad an assault is, I suppose.
Aye, if I was really bad at it and I murdered them, I'd probably need you, right?
I would do it.
If I commit an assault and there is two people to collaborate, I did punch you, right? I get a charge, I get a guilty, and I get a sentence. It's then aggravated by hate because I shouted at Tommy, you old bee, before I punched you. Only one person heard that.
Yeah.
That's enough. So then I would have a bigger sentence or not?
Yes. Well, that's the point of it. I mean, I must say, the idea of aggravations has existed since the 1980s, and the judges don't always act on it. So even when there is a conviction with an aggravation, I suppose they should say, well, you would have got 4 months, but before it's aggravated, you're getting 5 months. They don't, and certainly at the High Court, they don't always do that. I mean, at the moment, they're pushing for serious organised crime aggravations, which is a whole other subject. But the idea was, if you're involved in crime and it's related to serious organised crime, you should get a higher sentence. And I don't see an awful lot of evidence of judges actually giving people higher sentences. So it probably looks a bigger problem than it actually is. As I said, they need two witnesses to prove the assault or the breach of the peace or the threatening behaviour. They don't need to. But the reality is, if there's two people watching the assault and you're shouting something homophobic, probably two of them are going to hear it, So it looks quite interesting, but in practical terms, it probably not make a lot of difference.
Fingers crossed. The question that came onto the Twitter feed: how long do you have a non-hate crime staying on a police record?
I don't know the answer to that. I mean, this is the most worrying thing about it. I mean, in addition to my day job in court, I also do a bit of sort of legal commentating for a variety of different people. So I'm looking for things to write about, and I'm looking for things to talk about. And I was completely in the dark about this. This, when the Murdo Fraser story broke, I was actually surprised that we had a system, and this was only this week, that we had a system where the police were record. I knew they would record the fact that there was a hate incident, but the fact that they're actually recording your name as the perpetrator of the hate incident and apparently prepared to disclose it in certain circumstances to potential employers is absolutely frightening, So the fact that maybe you could want to be a coach or a carer or a nurse or, and the police could disclose the fact that you were half cut one night and you had an argument with somebody on Twitter, it's terrifying,
And not even factually broken the law, but just anybody complaining. And, somebody that runs a kids' football club, that a club our size will need 30 to 40 people to have a PVG done. Is that going to be more difficult? I mean, listen, my head's above the parapet, right? Yeah. I'd be shocked and stunned if in the first week somebody doesn't make a complaint about me. But
that's the problem, And that's what I think is the problem, Craig. I've gone on about this police thing. I think it's a real problem. But you know what people will do, and I've noticed this. I was interviewed by BBC Northern Ireland a couple of years ago, and I said the big problem is that somebody like me at this age, I don't fully understand the trans issue. I'm terrified to say anything about it, So whether it's about transsexuals going to prison or competing in sports and all of that, I might have an opinion about that. I'll probably just say I'm not talking about that because I cannot be certain that I'm not going to get reported to somebody. Now, I've got a legitimate view on whether people, there was the famous case a couple of years ago where the argument was whether the convicted person who had been born male, if I keep it neutral, should have ended up in a female prison. I've got a legitimate view on that, but I'm never going to talk about it on Twitter or even in any of the articles I write or anything because I'm terrified. I don't fully understand it. I probably get a legitimate view on it, which people would be interested in hearing. I believe, in comparison to my legal colleagues, I'm pretty outspoken in the sense I'll criticise the SNP government and I'll criticise the prosecution when I need to. But I'm terrified of that because I just don't know what the parameters are. I don't know what I might say that when I'm really actively trying not to upset anybody. It's still possible that I could find myself complained about.
That's scary. Now, the other thing that I found bizarre when I first read this was, and again, it was one of these things where I thought, that can't be right.
Mm-hmm.
I believe, rightly or wrongly, you might have a more learned opinion on this than me, but I think the worst crime that you may have to report as a person, as a victim, must be rape or sexual abuse, whether you're a female, a male, a child, or an adult. The worst crime is murder, but you would never be able to report your own murder. So as far as I'm concerned, the worst crime you would be expected to report would be rape. Now, that must be a horrific experience. Having to pick up the phone and dial 101 or 999 or walk in the door of a police station to give your story must be terrible. And I'm quite sure once you walk in that door and they speak to you, there's support mechanisms there to help you. You don't know that until you get in. So I think that must be a horrific experience. But what we've done is we've made it easier for people to make complaints on this than we have people who have went through the worst crime reportable in my eyes. Because, and I couldn't believe what I was reading.
It's been described as a sex shop. Legally, it's not a sex shop, and that's what it's been described as. And there's a mushroom farm in North Berwick or something.
Aye, we're both reading the same stuff and thinking. So what is the rationale behind making it easier to report this sort of crime than the most horrific crime that you should be able to report as a human being?
I'm guessing here, Craig, but the shop, which has been described as a sex shop, it's not a licensed sex shop, but I can understand why people describe it as that. It's at the back of the Corinthian where there's 2 or 3 gay bars, and gay discos. So I think the logic is that's there for people to report homophobic crime. It must be. It seems to me too much a coincidence that, there's the only place in Glasgow where there's 3 gay bars, and this place is right next to it. So I assume that's the logic of it. I'm bait so far as the mushroom farm's concerned. I'm bait on that one. And actually, again, like the recording, and I was unaware of this until 2 weeks ago, the idea that they set it up. I suppose they're trying to make it easier for people to report it. Your point is, well, why not make it easier for rape victims to report it? That is a fair point, and I've not got an answer to it, really.
Yeah, that is my whole point. I think these majority of people who are going to be victims of rape are going to be female. I think that's fair to suggest. And to be in a position where your choice is dial 999, phone 101, or walk through a door of a police station must be bloody horrific. So if you're going to make any crime easier to report, I can think of many that are justifiably easier to report and make it easier for the alleged victim at this point, because at the point it's just a complaint, than somebody who gets upset with something you or I may see on Twitter. It makes my head scratch.
I don't know whose decision that was, and you won't find it in any legislation. So I assume it was Police Scotland, with dealing with, for example, the gay community. Probably that was the idea they come up with, but you'll not get the answer to that anywhere, I don't think.
Yeah, it's something that's been asked on the Twitter that I've asked publicly as well. Where is the jurisdiction? Where does it start? Where does it stop?
Well, if a material part of the offence is committed in Scotland, then the Scottish court is jurisdiction. And my thinking is that if you're in London or Liverpool and you put on a video on Twitter or Facebook where you're saying, making some sort of homophobic comment or some anti-trans comment, and it's visible in Scotland, then undoubtedly the Scottish courts have jurisdiction. So you could find yourself in one of the English cases. Actually, most of the English cases are to do with sort of far right neo-Nazis. And there was people who went to California and basically they were stirring up racial hatred by making videos in California and putting them on, so that I can't remember, I don't want to say the name of the group, but one of the far right groups were circulating these videos, and they were prosecuted. So their argument was, well, none of this crime was actually committed in England. It was all the films, the videos were all made in California. So what right have you got to prosecute? And they said, no, you were stirring up hatred in England. The point was, you want to try to stir up hatred in California. You were putting the videos on in England. And that's more or less the way we approach it. It's easier. It used to be in the 1800s and the 1900s, you really had to be in Scotland to commit a crime. But now you don't, and quite often people are prosecuted in relation to people who've never been in Scotland. I've had cases where, people are based in London and they're sending drugs up or they're sending prostitutes up or something, but the offence is, even though they've never been in Scotland, the purpose is to commit the offence here. So I think there's scope for that. I mean, if you're right, they're going to be inundated with complaints in relation to things that are happening in Scotland. I'm not sure there's going to be a great appetite for prosecuting English people and Welsh people and American people, but theoretically they could do it.
Yeah, because the thing that I considered, again, when I was on someone else's podcast, and it's probably a ridiculous point, but it's a ridiculous law. If I was to go down south, the podcast the host was in England, so I'm talking in Scotland. So if I see something wrong, I totally understand. I could be hit.
Yeah.
But if I'd went to his house and recorded that, said something, came home, I could be arrested for something that happened outside.
No, unless it was published in Scotland. It would need to be published in Scotland.
Yeah. Well, so if I go down south, I record a tweet, I put it out in England. And this is a bit I need to be careful of, and I'm not trying to circumnavigate the law here. I delete it from my own phone before I come home, so I don't have anything in Scotland with this alleged crime.
Right.
But I filmed it in his home. We put it out through his channel. We put it out on social media, and somebody makes a complaint. Can I be arrested?
I think it could be argued. It would obviously it would depend on what you said, and it would need to be stirring up hatred to contradict this new law, or contravene it. So if you said something in a private conversation which was recorded that had the effect of stirring up hatred, and then it was published anywhere in Scotland, then I think they could argue they've got jurisdiction.
Because then that led me to an even more bizarre point. If I'm Spanish and I live in Madrid and I say the same thing on Madrid, and I come in Scotland on holiday, can they then arrest me? I know we're getting to ridiculous points here, but
I think they could. It would be a remarkable police operation to put all that together. But theoretically, if they thought you had committed an offence in Scotland, I mean, for this kind of thing, they probably are not keeping people in custody. They're probably filing a report and sending it to the fiscal. So, quite dramatic for somebody to be arrested. But I suppose if the case had gone to court and the Spanish person hadn't turned up and they'd taken a warrant, then when he or she arrived at Glasgow Airport, the passport check might flag it up. I don't imagine there's going to be a lot of, I'm not sure we Nacho Novo or anybody's get very much to. I don't know if you were thinking of him.
No, I wasn't thinking of Nacho, because the thing is, you need to understand the hates was said with Nacho. And if you're ever in his company, that's quite, I love him to bits, but you could get away with it with lack of evidence. But what I was thinking on more when I talk about jurisdiction, and I think it's the type of person who could, people like J.K. Rowling. People like, oh God, what's his name? It's in Bulgaria hiding now, and they're trying to extradite.
He's in jail, isn't he? Andrew Hunt or something.
So these people who are quite high profile, right? Say somebody like Joe Rogan, the biggest podcaster in the world. Now, he's already had a pop at the Scottish Government on a podcast. So if he was to do something a step higher, comes to Scotland for a game of golf, he's well known to a lot of the population in Scotland, and somebody phones up Police Scotland, walks into the non-sex shop, but place that sells cucumbers and stuff in Glasgow, and said, that man, look, right, that's the type of ones that I'm worried about, J.K. Rowlands, Joe Rogans, etc.
Yeah, well, she's a target, and I don't think many, if we're entirely honest, I don't think many people suspect that 75-year-old people are going to start inundating Police Scotland with complaints that somebody's stirring up hatred on the basis I'm 75. Where it's been weaponised is in relation to people like J.K. Rowling and Joanna Cherry, both of whom are targets. And I think there's a particular individual who has said that she's going to report J.K. Rowling to Police Scotland as soon as this act comes in. She said it. And, there may well be other people who are going to do the same thing. And I only know those two. There's a lot of women who are constantly in a state of argument with other women because it's become a sort of question of women's rights against trans rights and where do they intersect and so on. So I'd never heard the word weaponised until this act came in, and what people are saying is this is going to be weaponised. It's going to be used to say, well, I contributed to a crowdfund the other week, a civil servant who had said at a conference that only women menstruate. I think we talked about that, and she found herself sued in court, for saying it. So if somebody's prepared to go to the length of raising a civil action against somebody for saying that, which most of us would regard as pretty non-controversial, it's nothing to pick up the phone to Police Scotland and say, look, I was at a conference and this woman said this, I want her arrested.
I need to clarify that, because that's one of those things I think I hear, but it sounds so ridiculous, I need to double check.
That's true.
So someone at a conference basically said that women and women only can have periods.
Only women menstruate, that's what she said.
So basically, there's only women that can have periods, and that led to a complaint. I take it that never led to a conviction.
A complaint, a civil action.
Sorry.
A civil action. So it wasn't judged as a criminal offence, thank goodness. But the point when I made a contribution to the crowdfund, the girl who made the comment was trying to raise funds for court fees because she'd been sued in the civil courts in England. I read this week, in fact, they're continuing with the action. She's been dropped out of the action, as I understand it. But they're still continuing against their employer on the basis that they have not taken sufficient steps to guard against this kind of thing. So I don't know the detail of it, but it seems to me if you're prepared to raise a civil action on the basis of something like that, it's not a big step to think that the same people might phone the police and say, well, we're not charged with it.
Yeah. I think that brings me neatly on to something that I've held as an opinion and a question through all the trans stuff, and without getting involved in that, and understand why you wouldn't want to get involved in a discussion about trans rights, etc., etc. But I've said that the most unwoke people in the world must be coroners. And the reason I say that is you or I are not allowed today to guess somebody's gender. You can be ridiculed by society for doing so. And you can misgender them, right? But every coroner, or what I can't remember the other word I'm looking for, pathologist, that goes to a murder, a body, an unidentifiable body, and maybe a fire, etc., or decomposed because the body's been dead for so well, can normally tell us two things: the age and the sex of that person. So the next time they go to a fire and they say that is a male in his mid-30s, how did they know they've not misgendered that guy? And that's how, and I don't think this is ever going to happen, right? But this is how ridiculous the whole thing becomes. That how can a pathologist say that's a man if they've not asked for his pronouns before he died? And that's where society is. I just think it's a good way of showing society for what it's worth now, that it's just absolutely ridiculous. Is that fair to me to say that? And by the way, if a pathologist was to do that after the 1st of April, could they be sued under hate crime?
You kind of reminded me of the old joke from the American trial where the lawyer asked the pathologist, how many autopsies have you done in dead people? And she said, all of them. So I suppose you've got a point, but there's not going to be anybody about to complain about being misgendered if they're the subject of a post-mortem at time, But I suppose theoretically, everybody needs to be careful, in England, we've not quite had it yet, but in England, the Bar Council has given barristers guidance not to say ladies and gentlemen of the jury. They're told not to do that any longer.
Because apparently we have more than two possibilities there.
That's the logic of it. And we haven't yet had guidance, but something we're talking about, and if you've been doing the job for 40 years, you say that instinctively, like you say good morning, so, but it is an issue that, I was reading a report of an identification parade last week, actually, and for the first time I noticed that the question used to be, you gave a statement to the police, you said you were assaulted, and if you see the person, give me his or her number. And that's been changed now, it's so at every level, people need to be careful. And, some people are trying to cause offence. Most people are not trying to cause offence, but might say something which, might cause offence. And that's the worry, that most people just say, well, if that's the risk, I'm not going to express an opinion on anything any longer.
And that's the key to this for me. I'm a believer in free speech, but I'm also a believer in that doesn't give you carte blanche to say what you want. You've always got a responsibility of saying the right thing, right? That's not, you can't, free speech, I think, is allowed and it should be protected, but we should all be able to, society should be able to draw its limits on where it is. No, some people further up the chain that decide this is what we're going to do. But you're right, and a lot of people will now refrain from using that right of free speech because they're afraid of the consequences by saying something wrong, not saying something hateful, not try to tell you Hitler's a great guy and the Ku Klux Klan should be running the government, but by saying the wrong word or the wrong phrase could see themselves being ridiculed, not only in society now but in the law. That, I think, a byproduct of it is free speech, and not illegal free speech. It's going to be reduced. But here's the kicker. I think, my opinion, I would like to your opinion on this matter. When the Offensive Behaviour Football Act came in, without talking about certain teams, I think it's safe to say that there was one group of football fans who thought, oh, you cracker, that other group are going to get arrested a lot. But then when the arrest started, it was probably eaksy-peaksy, or one side a wee bit more than expected. And what I think happened there is, and I think this is going to repeat with this, let's say the woke people that think they can never do anything wrong because they'll call somebody and gender somebody as an alien cat if they so wish, and they always think they're on the right side of history in any argument. They do not believe they can do anything wrong. People like me who know fine well, I've seen it cut mountain, are going to get targeted by a complaint, at least one, and probably the 1st April.
More than one, I predict.
Sorry?
Probably more than one.
I will. Thanks for the confidence there, Thomas. I do appreciate it. I take it I'll get a card of one of your colleagues on the way out the door that can specialise my defence. So, right, my realistic set.
Yeah, because they'll target you. You know, people will target you.
Yeah, and you know,
that's the worry, isn't it?
Aye, and the frightening thing is, I'm no J.K. Rowling or Joe Rogan, right? I'm just a guy with an opinion that gets between 10 and 100,000 views in a video, right? Yeah. But that's enough for people to target me. So I know that in the 1st of April, I will be more considerate of what I say. I will consider more my words before, you know, even today, and although I do consider my words wisely today. However, I believe that those on the woke side will not change anything. Because they do not believe they can do anything wrong. And perversely, I think that will be their downfall, because they will attract possibly as many complaints, as many investigations than people that they term to be the offensive part of society. And I saw that in the Offensive Behaviour Football Act. Do you see this as a possibility as well?
I really think that's the biggest problem, Craig, that the legislation, everybody's talking about the legislation. I don't think it's going to make really much of a difference. But you take the issue of a transgender identity and the placing of people who were born male in female prisons. Big issue, a big issue. Now, in any big issue, there are usually two sides being presented. Now, the side who think that the minute you identify as a woman, you should go to a women's prison are pretty vocal. The people who might be on the opposite side would have a legitimate argument about protection of women, but their numbers are going to be few, because people will think, look what happens to J.K. Rowling. You know, J.K. Rowling comes out and she makes a allegation, or she makes an argument that I don't think anybody who was born a male should end up in a female prison. And, you know, she gets all sorts of abuse. She's getting threats. Joanna Cherry had to go to court because somebody threatened her over it, you know. So most sensible people, and I hate to use that word, but most people will look at it and say, I'm not going there, you know. I'm not getting involved in a debate about that because I've got kids, you know. I don't want my kids being upset because I'm getting abuse on Twitter or something like that, which is a concern for all of us, you know. We've all had it. And I think that's the problem. So you end up with only one side of the argument, that one side, you know, what you might call the woke side, are very vocal about it. And what would normally follow the opposition argument, people are just walking away from it and saying, well, I don't need this because I'm going to get reported for a hate crime. And if that doesn't happen, I'm going to get threatened on Twitter and all of that. You know?
Aye. There was a similar personality to the J.K. Rowling stuff that I picked up on probably 6 months ago. Sian Davis is the swimmer.
Yeah,
now, I'm a big Sian Davis fan, but it wasn't through her swimming. It was that Gladiators programme when I was at that age that could be impressed by such a thing. And I follow her on Twitter.
Yeah.
And I only started doing Twitter again recently. I hated it 10 years ago when I was previously on it, but I've been on it again and I'm a wee bit more mature and I can handle it a bit better. So I've been following Sian Davis. Now, she makes a great point. She says back in her day, she was competing against folk who had an unfair advantage because Eastern Bloc countries were all taking drugs.
Yeah.
That's factual. That's not for debate. She says, in today's athletes are against an unfair advantage with people who are born with different hormones.
Yeah.
Now, nobody can argue with Sian Davis's opinion in that, because Sian Davis is an athlete, and it's very, you know, it's like you talking about law. You've got a far better opinion on that than me, and so quite rightly so. She gets shouted down, and you think Sian Davis is not saying anything about changing rooms, how people should be, you know, pronouns. Sharon Davis is just making a single point that she repeats very, very particularly and well. And in some people's eyes, Sharon Davis is the devil. And you think, this is mental. That's where society is. However, there's a great question came on Twitter, and I think it's a great question, but I actually do not have a clue what Duncan's asked me here. Duncan says something, and if you don't understand this question, we'll get bothered. Does Section 29 of the Scotland Act make the Hate Crime Act unlawful?
I think, I don't have Section 29 up, but it's incompetent for the Scottish Parliament to pass legislation which is incompatible with the European Convention on Human Rights.
Okay.
So I think that's what he's talking about. Maybe he can come back if I've got that wrong. You know, one of the giveaways in the legislation is that there's actually a part of it which says that it doesn't affect, I'm paraphrasing here, but it doesn't affect your Article 10 rights of freedom of expression. Now, they don't need to say that in legislation because that applies to all legislation. So they're not allowed to bring in a law that affects freedom of speech for, I don't know what that means any longer, but theoretically they're not allowed to bring it in and take your human rights away. Now, the fact that they actually write that into the legislation makes me think that at the point when they're drafting it, people are saying, this looks as if it's non-compliant with the Human Rights Act. So we'd better actually write into the legislation that it is compliant with it. So it's really, do you know what I mean? It's saying nothing. You know, any law has to comply with the human rights legislation. So they're saying that when the court is considering whether what you've said amounts to stirring up a stirring up offence, they need to take account of the fact that Article 10 gives you freedom of expression. Now, I don't know how any sheriff would balance those two things, you know, because if you get freedom of expression under Article 10, you can say anything, but we all know that you can't say anything. So it doesn't really, I think somebody might have a go at arguing it's non-compliant. It's probably not going to work until we know the situation in which it's going to be used. You know, it could only be discussed at the moment in a vacuum. What offences are likely to be prosecuted? I actually, and it needs somebody to be prosecuted, and I'm not certain that anybody is ever going to be prosecuted because I think the Crown would always opt for a different offence, you know, which would be easier to prove.
Yeah. So what it might do is, though, it might just be attracting more complaints, which might lead to prosecution, but might lead to prosecution over current legislation and not this new thing.
Well, we've had a stirring up offence for 60 years. It's like stirring up racial hatred's been an offence in Scotland for 60 years. I've never known anybody to be prosecuted for it, you know. And this is essentially the same offence extended to different protected characteristics.
Yeah, I mean, my opinion is, I think hate is an emotion, right? And I think society is well able to draw the line in the sand and what is not acceptable, because hating someone that broke into your house, or hating somebody that smashed your mother, or hating somebody that killed your brother, I think society would quite accept that level of hate. But, you know, hate somebody because they drink a different type of milk for you is just ridiculous. And I think as society, we are grown up and adult enough to draw our own line there, that we don't actually need this legislation from government. I think when you're trying to drive now the emotions and the acceptable line of emotions for society, I don't think that's your job.
Well, I mean, that's where you've struck right on it. Where is the acceptable line? I mean, nobody would want to see people stirring up hatred against the transgender community. Nobody would want to see that. But people are fearful. Well, if I say that, might it be, one, seen as stirring it up, and two, even if it's not stirring it up, am I going to be logged by the police as somebody who perpetrated a hate incident? So it kind of shuts down discussion. You know, people will just shut off and say, well, I've got nothing to say about that because I'm worried if I actually express an opinion that might, end up worse for me.
No, listen, Thomas, I say to all my guests, the best gift you can give anybody is your time. So I can't thank you enough, particularly on a day, for those that are watching this, we started recording it just before lunchtime. It's a working day. You've been at court, I take it, you get adjourned for some reason. Yeah. And, you've been good enough to phone me and come in and organise this. So I can't thank you enough for doing that. I think one of the takeaways from me is, society thinks this is going to be filling courts and filling jails. The fact that you, with your vast knowledge of law, court, prosecutions, is suggesting that it might be much ado about nothing. That gives me a wee bit of faith, but I think until it gets normalised, it's just going to be a car crash, because you've already suggested that I might, in the 1st of April, be more than one, and I'm kind of worried now that somebody with your knowledge should suggest that I'm going to be more than once. But that to me is going to be the biggest thing. The strain put in place, possibly the courts, if it even gets that way. You're suggesting it might not, but it's just, can this be repelled? By the way.
It could be, aye. I mean, I think it would probably take a change in government, which could happen next year. But I mean, some Labour MSPs have come out in Twitter and social media and criticised it. They voted for it, they voted for it, and I know why they voted for it, because if they'd voted against it, it would have been, it would have been presented, well, we're trying to fight racism, we're trying to fight, anti-transgender behaviour, and Labour Party are for it. So, don't vote Labour because they didn't stand up for you. So, I mean, having voted for it only, a couple of years ago, it would be extraordinary if Labour then came in and repealed it,
But this is a bit that I always struggle with. I think equality is a fantastic notion. I think equal rights for everybody is a fantastic place for society to aim for. And if that is the true aim of this, why do we need any protected groups?
I mean, there's an argument. All the groups are already protected by the existing law. I think the legacy of the Stephen Lawrence inquiry is that they think it's a good idea to know what the level of hate is in society. So, so if before we had aggravations, breach of the peace was just recorded as breach of the peace. So if I'm drunk one night and I smash my neighbour's window or cause a disturbance in his garden, that's recorded as a breach of the peace. If I go to a political march and I'm shouting neo-Nazi slogans at, anti-racist complainers, in 1980, that was recorded as a breach of the peace as well. So when you looked at the statistics, you couldn't tell whether it was a drunk breach of the peace or a racially motivated breach of the peace. That's the logic of it. So the minute you start having specific hate offences, then you can judge the level of hate in society and whether there's a bigger problem in 2024 than there was in 2020. And we can come back and look at it in 6 years and see, is the level of hate lower or higher? The problem is you can do that without putting somebody's name to it. So, we talked about Murdo Fraser's example, and they could have logged it. Somebody put, X put on Twitter the following comment. That shows that there's that concern at that time. Recording it against an individual and then possibly disclosing it to a potential employer or something. That's the really, really terrifying thing about it, rather than the prosecutor. I mean, nobody wants to be prosecuted, and if you're working, it's going to cost you in legal fees and so on. Nobody wants all that, and potentially, if it's seen as hateful, you could lose your job over it, I suppose. So I'm not saying nobody should worry about it. I just think that when there's so many easier ways to go about prosecuting somebody, why would you complicate it by taking this legislation to court?
Yeah, I think it's fair to assume, listening to you, that your biggest fear is not in the end result of it, i.e. convictions and stuff. It's the reporting of it and how that could affect people. I mean, we spoke about jobs.
Yeah,
I mentioned me involved with a kids' football club with volunteers. Simple things like somebody said on Twitter about going on holiday to America and these things, where you can't have criminal records. And all these things could be affected. And just for pure clarity, though, there you used 2 examples of you going and smashing your neighbour's window and you going to a hate rally.
Yeah.
These are not true examples. These are just.
No, I never smashed. No, I got on pretty well with my neighbours. That would be vandalism, actually. That was a pretty bad example. But I mean, that's the kind of, it's a kind of recording. That's what they say. It's if you don't specify it, then we don't really know what we're dealing with. I mean, breach of the peace was once defined by anything the police don't like, so it covered in quite a wide spectrum. And so if it becomes a racially aggravated breach of the peace, then they can see how many of them there are. Do you know the other problem, and I mention this because non-lawyers probably wouldn't see this, but it creates another problem that these kind of policy-driven offences, often the prosecutors who are actually in court are told that they're not allowed to delete the aggravation, So because it's become important to the government to see how much racial hatred there is, for example, people will go and say, well, look, I'll plead guilty to the assault, but I'm not accepting the racial aggravation because it had nothing to do with the race. Me and the guy just hated each other and it was building up. Quite often, and I don't do work at the sheriff court, so I'm getting this secondhand, but people will say to me, total waste of time. Guy was prepared to plead to assault, wasn't prepared to plead to the racial aggravation. The prosecutor said, I'm not allowed to delete the racial aggravation. And years and years ago, I had a case where a poor guy, a black guy, was in Glasgow for some business-related reason, got a kicking from 2 thugs. Must have been quite a bad one because it went to the High Court. I wasn't involved in it. But the prosecutor had been trying to get the guy back to Glasgow, and he phoned him and spoke to him on the phone. And the guy said, look, I'm a successful businessman. This is going to cost me a fortune if I've got to come back to Scotland for this case. Is there anything that can be done? And he went to the lawyers and said, look, this is the situation. Would they plead guilty under deletion of the racial aggravation? And after a bit of to and fro, they come back and said, all right, well, we'll do that. And he phoned the guy and said, it's looking good. I've spoke to the lawyers. They're prepared to plead to that. Went to the superiors in Edinburgh. I wasn't allowed to do it. So the guy had to fly back from wherever he came from. He stayed abroad, Spain or France or somewhere, had to fly back. And the case then became all about whether it was, so maybe people think that's a good thing. Maybe people think we need to do it. But, other people probably think that, well, if the person who was the victim is prepared to proceed on that basis, maybe it's wrong to spend 5 days in court arguing about whether it was racially aggravated or whether. I mean, there's plenty of people getting a kicking in Glasgow city centre when it's not racially aggravated. We all know that. So we can see that at least it might have been doubtful whether race was involved in it at all. Yeah, and this has got the same potential where, people will say, well, look, I'm prepared to accept I did a bad thing, but it had nothing to do with the protected groups. And the prosecutors might have their hands tied behind their back where they're saying, well, this is an important policy and we're not walking away from it. So go into court and argue that it did have something to do with it,
It could be politically driven. But am I right in saying, you said earlier, if you were charged with assault with an aggravation and you couldn't prove the aggravation, does the whole case fall? Or do you just, so you'd only get one hit at it?
One hit at it, aye.
So it could cost convictions. There could be potentially people out there who do things that are bad, and if they try to attach this aggravation to it, could walk out of court. I mean, you work in the defence, so you wouldn't be that. It would work for you.
I mean, I don't work at that level. We're not seeing it. So as I said, it's all kind of second hand. But if they charged it as an assault and they don't prove the assault, then that's an end of it. If they do prove the assault, then the judge then has to consider whether it's racially aggravated or aggravated by homophobia or something.
But the assault charge could still stand if they don't prove it. Right. So they do that, in effect, get 2 hits at it there as well, lobbing it on and bolting it on.
I think that's what I said earlier, that they don't lose anything by adding it on. In a way, they do lose something because they lose the discretion to walk away from it. So once they've charged it, it seems that it's then kind of policy driven. So, you know, you hear about plea bargaining. It's not as detailed in Scotland as it is in America, for example. But equally, lawyers will go to the prosecution and say, look, it's got nothing to do with race. It was just a fight between two guys. So we'll plead to the assault. And they'll say, no, we're not allowed to delete the aggravation. So either he accepts it's racially aggravated, or we're going to have to have a trial over it. And they could have a trial. And I think this is what you're driving at now that I think about it. They could be basically put into a situation where they had to have a trial, and the witness might come across as incredible, and the sheriff might just say, I'm not even sure there was an assault, or I'm not even sure there was a breach of the peace. So they've got an offer for a conviction, and because they want this sort of policy-driven aggravation, the witness comes across as argumentative, and there's no conviction at all, and, you know, that is not a good outcome. So it's probably not as simple as I initially made it sound. I think if these things, I mean, the way we used to make developments in the criminal law was, you remember, I think you're old enough to remember that glue sniffing was a problem, and Scottish law never really covered it. And for a time, people were saying, well, it's not good that the 15-year-olds are buzzing glue and getting out their faces and having health problems, but we don't really have a law to deal with it. And eventually there was a law that dealt with it, you know. And so that was coming up for the streets, where people for the streets were saying there's a gap in the criminal law, we need to solve it. This is the opposite. This is coming from government, and people in the streets are saying, do we really need this, you know?
That's something that, again, it's not nothing to do with the reason for the podcast. I suppose it might be, actually. Why do we have two different legal systems?
What do you mean to do?
We've got Scots law.
Aye.
We've got this law. It's Scotland. We have a slightly different way of prosecuting people. The courts are set up slightly different from England. But why?
Well, we had courts before we were in the same country as England, you know. So, and actually, there was Scottish law before there was the Act of Union, and then there's been Scottish law since the start of the Scottish Parliament. And it's the period in between, really, it causes the confusion, because there was a lot of UK legislation, which is still law in Scotland. And to complicate it even further, there are still reserve powers to Westminster. So, for example, if the Scottish government decided there was a big problem with firearms law tomorrow, they couldn't do anything to cure it. They would need to get a Westminster Act to deal with firearms. So it is, but I mean, it really comes from the fact that we had our own, Scotland had its own legal system before it was part of the United Kingdom.
Yeah, I totally get that. And pre-1707, there was Scottish judicial system, and I understand that. Yeah. And, you know, if we had decided that we were allowed to burn witches pre the Union, and we still wanted to hold that as a law, I can kind of get that. But what the bit that I just don't get is, after 1707, how did we still have this ability to bring our own laws into place?
Well, we never had the ability to bring in new laws from Parliament, but most of Scottish law, until fairly recently, just came up through the judges, you know. So judge-made law, you know, you asked me, where do I find the definition of an assault? Well, you won't. You know, it's not in an Act of Parliament. It was just custom. And obviously there's been a lot of reported cases. So if you want to know what is an assault and what's not an assault, you actually go and read what the appeal court has said about it in Edinburgh. It won't be defined. And this is the other branch. And some countries, it's all written down. Both England and Scotland have common law offences, which have existed since the 15 and 1600s. And then there are things like this, which are written by parliamentary draftsmen, you know. And actually, it's the ones that are drafted which cause most of the problems. You know?
So it certainly seems to be. Well, Thomas, I say thank you very much. I do appreciate it, especially in a day where you've been at court this morning. I've been talking to you for a wee while now to try and get your opinions on it, and it was great that you'd contacted me early enough this morning to say, look, you may be able to skip away from court. So I'm delighted for you to come in. Thanks very much for that. Disappointed you've not got your wig.
You could be doing one as well.
Thank you very much. No, hold on a minute. If I don't put this video out until after the 1st of April, right? And you've made a comment which is definitely aged.
I'm looking. There's no it's not a protected characteristic.
Age is?
I wasn't talking about age.
Aye, but you're making the suggestion I'm bald because I'm old, right?
I know, but I'm older than you.
Listen, I know a good defence lawyer. Have you got one? So, again, Thomas, just thanks very much. And I'm sure this will enlighten a load of people. So I'll just finish off now by saying, as I always do, if you've enjoyed the podcast, give us a thumbs up, subscribe if you've not already, and join in the comments below because they're always a good laugh. And the most important thing of all, I always say, unless you're Hamza, one of these stupid lawmakers, or a cult member in the SNP, have a great day. Cheery bye now.